Hey everybody, Benjamin Keck with Keck Legal here. Today I want to talk about a topic that comes up quite frequently with a lot of my small business clients. Let's say maybe you have a restaurant, for example, or a store that you're looking to open. Well, there's usually a lease that goes along with the space. Maybe you're leasing an office, a restaurant, a store, whatever the case may be. And typically, the way you're going to structure it, because it's the best way to structure, is you will have your LLC set up to run the company, and that LLC will be the tenant under the lease, and this is very normal. This is the best way to do it. You could personally sign the lease, but now you are personally on the hook for that lease. So typically what we're going to want to do, we're going to want to have the LLC, an LLC set up as the tenant under the lease. The tenant will be your company. We'll call it ABC LLC. And sometimes the landlord will insist on a personal guarantee. Not always, but often, depending who the landlord is, they may want you to sign a personal guarantee where you are guaranteeing the rent payments under the lease, possibly you. Maybe if you have a business partner or multiple partners, perhaps the landlord may want personal guarantees from all of you. First of all, let's think about this. Why do you set up an LLC in the first place? Well, it's to protect yourself from creditors. Well, if you owe the landlord rent, they are now a creditor. And basically, if you sign a personal guarantee, you are now removing the protection that an LLC gives you as to that landlord. So even if you've got your LLC set up as the tenant under the lease, if you've signed a personal guarantee and for whatever reason your company cannot make those rent payments, let's say your store never opened, things didn't get off the ground, there were all these problems, and the landlord just says, sorry, you still owe me the rent. In fact, in most states, certainly in Georgia where we operate, the landlord can charge you the rent for the entire term of the lease. So let's say you signed a 10-year lease, and worse, let's say you personally guaranteed that lease. Well, guess what? If you now breach that lease because of whatever the circumstances may be, that landlord can now, if you've signed a personal guarantee, come after you personally for the entire 10 years of rent. Now, certainly if they find a new tenant, they would have at that point mitigated their damages, is what we call it. And in that scenario, then their damages would be reduced. They can't double dip. They can't charge you and the new tenant simultaneously. However, they may just not release the space and just keep running the tab against certainly the LLC. So without a personal guarantee, all the landlord would have is a claim against the company. Well, in my example I gave earlier of a company that just never got up and running, there's probably nothing there for the landlord to get. So the landlord could sue the LLC, and you could put it into Chapter 7 or just wind it down and say, hey, there's no assets here, if that's true, of course, and the landlord could get a judgment for unpaid rent against the LLC, which may be worthless. However, if they get a judgment against you personally, now they can go after all of your assets, and now you're looking at potentially a personal bankruptcy filing to protect yourself from that. So that's why it's very important. Anytime you are potentially negotiating a commercial lease as a tenant, you're going to want to get an attorney to review that, and you're going to want to make sure that you understand exactly what could happen if things don't go according to plan. Of course, I would advise all of my tenant clients to try not to have a personal guarantee if it's possible. Sometimes the landlord simply won't do the lease without a personal guarantee. There is the possibility of a middle ground of a limited personal guarantee. For example, you may, this is oftentimes something that's negotiable with certain landlords depending on the situation and how flexible they're willing to be. Sometimes you can negotiate a limited personal guarantee that, for example, let's say you might guarantee the first year or the first 5 years of the lease payments, and then after that point in time, if you've made all of the rent payments, then the personal guarantee falls off, it expires. Or alternatively, another option is to have a limited personal guarantee as to amount where, let's say, you'll agree to personally guarantee the rent up to a maximum of $50,000, whatever the case may be. So you know that they can't get a judgment against you for $1 million. It's limited and capped at that amount. So those are the sorts of things you want to be thinking about if you are negotiating a lease for a space for your company. You're going to want to have these things in mind, and you're going to want to talk to an attorney and have them review the lease documents before they sign them, especially if the landlord's asking for a personal guarantee. If you have any questions, happy to help here at Keck Legal. Our website is www.kecklegal.com. Thanks, everybody.